Mr. Bozeman, will you lead us in the invocation and we'll do the Pledge of Allegiance?
Let us pray. Heavenly Father, we just come today, God, just thank you for an opportunity to be back in your presence, guys. Thank you, Lord, for the opportunity to serve this county. Lord, I just ask you just to be with us as we make decisions in the way we should go in this county. Guys, thank you for the men who stand here with me and the women that help to make the decisions. Guys, I ask you to be with us as we go through this thing. Lead us, guys, stretch, and then we pray. Amen. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. So everybody had a second to look at the agenda. Any changes we need to make to the agenda? Hearing none. Item number 1 is approval of the previous minutes. Has everybody had time or had a chance to look at the minutes from our last meeting? Be October and November.
You gonna do them as a whole, or?
So what we'll need to do, since Mr. Lovern wasn't present for October, and then Mr. Dewberry wasn't present for November, we'll have to do them individually. So in regards to October, I would entertain a motion to approve as written.
Have you got the October minutes? I don't have a copy of them here with me. I want to look at them real quick.
Emailed them to you.
Yeah, the only one that showed up in my box, because that's what I kept looking for, was the one from today. So I don't know if it's got something to do with that file buffer thing. And I don't have my other phone with me, which has got that on it.
October and November. I know you weren't here for November, right?
Right.
I believe, if I'm not mistaken, October was the meeting when we had to call in.
Right, I was on the phone
So
for
it
that
would
one.
be,
Somebody needs it, there's no way.
myself and Mr. Dewberry, and Mr. Bozeman, I believe, because I don't think he was here either, right?
Give me just one sec, because I know what we. Yep. Okay. I'm ready now. I'm sorry. Make a motion to approve them as written.
Second.
Got a motion and a second. All in favor that were present at that meeting, raise your hand. Motion carries. Moving on to the November meeting. I believe everybody was here except for Mr. Dewberry. So I would entertain a motion to approve those minutes as written.
I'll make a motion, we accept them as written.
I'll say it.
We got a motion and a second. All in favor? So motion carries. All right, moving on to item number 2. We need to select our presiding officers, which would be chairman and vice chairman. And I believe that is a position for 12 months, correct? Is that what we just went into?
Yes.
So the way we'll handle that, and Nicole, you can correct me if I'm wrong, we'll take nominations first for one office at a time, and then after we get all the nominations, then we would vote. So we'll open the floor to nominations. And I will start. I would like to nominate Jason Halsey for chairman. Any other nominations?
Yeah, you. I'll nominate Adam Buddy, who's current vice chair for chairman.
Any other nominations? All right, we'll close the floor to nominations. And we'll move to a vote. All in favor of Jason Holsey, raise your hand. So that's 3. All opposed, raise your hand. You gotta be one or the other.
I'm not opposed or support, I mean, we didn't get to the vote part where I was gonna vote for you, that's basically my point.
So that would be 3-2. Or one, so you're abstaining for the official record?
For official record.
So Adam Buddy, raise your hand. And I don't know. So we got 2. And then all opposed?
Was that for vice?
For chairman.
Chairman. All opposed.
So that would be a 2-1-2. Okay. So Jason Holsey would be our chairman. Moving on to vice chairman, we open the floor for nominations.
Nominate Adam Buddy.
Any other nominations? So we'll close the floor for nominations. Given one candidate, I guess I would remain as vice chairman. Is that correct? All right, Mr. Chairman. You ready?
Don't take effect in January.
I think it says immediate.
Bylaw says January.
I think it says immediate.
I mean, the next thing on the agenda is review of subdivision ordinance. I probably don't want to got anything on it anyway. I'm gonna start with it. We'll go, the last time we were here, had a lot of discussion, so I took the official, resolution that was adopted by the Board of Commissioners on January the 24th, is actually adopted this will be effective January 24th of 2024. With that, we started looking at it previously with another copy, which I believe after going through a lot of it is really, it has a date at the bottom of 5/30/2025. But I think a lot of it, after going through it, it is pretty much word for word for what was adopted. The confusion was with the date on it.
Mm-hmm.
And then the other portion of the confusion was brought upon that Municode is a total different chapter, section, that's what's published for the public to see. So I think that's where a lot of my confusion came in, because I was using Municode as what was there. But we can still go through it. I don't know if how many of you looked at what was in comparison to it. But I've gone through it. It really starts in the definition portion of what I have around lots, lot areas, depths. I don't know how you think we should proceed with it. As I say, I'm all the way down through approximately, I think the current page would start at lot 14, where I have gotten to in comparison of the two. So, but I mean, I start in the definition as far as lots. I mean, you know, I can read what's stated, and I'll tell you what my question is when we talk about it and see. There again, you know, I'm not sure exactly how you would proceed to change this as far as it'd be a revision of the ordinance. What, obviously, the ordinance that's adopted is how it would be now, maybe some clarification. The first one is lot area. On it, it's the total horizontal area lot within the lot lines, lot excessive public road, exclusive of public road, right-of-ways, or private road, or access easements where they exist. So that would be in the ordinance, the current ordinance as it states, that is how it states, but my question is, when we use the word exclusive of public road right-of-ways or private road or access easements where they exist, there is times that a piece of property has access easements within the boundary lines of the lot, so I'm not sure that lot area is an accurate definition. See what I'm saying?
I'm reading it. And you said there's times that what now?
There's times that we have a lot for a parcel that may have an easement that was existing across that piece of property. If we take the area, the easement's not, is still part of the lot. In other words, by that statement, you're going to have two areas on a piece of property that's bounded by their boundaries.
So should that read inclusive instead of exclusive of public road, right-of-ways, private road, or access easements?
No, it should be exclusive of public road and right-of-ways and/or private roads, but access easements, that's what they are, they're easements. They shouldn't be, that area would be included in the lot if it crosses it.
We just need to move access easements where they exist after the comma and then exclusive of the other ones.
Correct.
Do you want to just strike or access easements?
Well, I would. I mean, I don't know why I would even need that, part of that confusion to be in there.
I agree.
If that's an easier legal way to do it, then just strike it. As long as doing so doesn't create further confusion down the road.
I mean, the lot area is basically the boundaries, whatever the area, the legal aspects of the area,
Okay.
would be that. Then, the only other, the lot through, see lot, there's parentheses on one side of that. I mean, I'm being nitpicky here, but if we're gonna change it, let's change it. It's just parentheses, lot, comma, double frontage, there's no close of parentheses for that, close that statement there. Like I say, it's just a typing thing, it didn't get picked up. Then down on lot record, I got a question on that, I'm not sure how that was, because there was an actual date. When you read that, the previous had a date of January 23rd of 2024. For some reason, that was taken out and a line, just a line placed there. So what I think the intent was is that lot of record, this new ordinance would not affect, taking in effect, that's the line of demarcation of where this ordinance is. If it was previously there, this ordinance doesn't supersede or change anything. I think that was the intent.
Yes.
So that
So
would
we
just
need to
be.
put the date back there for this ordinance.
We'll just have to see if the new effective date would be the one that needs to be but I doubt it. I think it would be what the intent was, which would be that January 23rd.
Yeah, I would think that because of the change of it, I wouldn't, anything done between January 23rd and whenever this new one comes
Would
should,
fall under
should
this.
fall under this. Okay. Then, just for the next one on it right there, you won't see it in the, I guess I'm gonna call it the redacted one here, but it's kind of the way it is, but all of those lots, there's all those definitions, it's lot something. There's 4 of them that pertain to a detail that is shown on page of the actual ordinance on 7 that describes lot depth, frontage, width, and area. I think all 4 of those should be grouped together preceding that detail. I know they're in alphabetical order. I get that. Maybe have lot and all of these others be a subsection under lot that has a description that would kind of, or you could put in parentheses to each one that has part of that detail, see detail or something like that, some way to correspond that graphic that's behind the last one of lot width. It shows, it's clarification for all those lots through there. Somehow tie that graphic, maybe a number and see a graph number or something like that.
So do you want it to say see lot definitions, or, because that's
Yeah,
how
you could
that's
see-
labeled, or do you want to label that graphic?
I mean, however would be, you could see lot definitions, graph or whatever to each one.
As shown in detail.
Yeah, somehow give that graph a number, and you could put it in there.
If you are gonna redo that illustration, though, I would give some examples of what odd looks like. Because this right here, this lot depth, you know, it's the average between. If the road was running at an angle, lot depth being in the middle,
Yeah.
not on the edge.
Yeah, there's,
I think there's a couple of illustrations needed that just give examples, because here, if the building line was where the lot frontage line is, then the lot width would be down there at that angle, not up there where it's at.
yeah, I mean, I think it just kind of, I looked at that, I struggled with that, but then you got flag lots, then you got all, you're gonna have 30 different examples, and somebody's gonna come up with another one that's not gonna fit, but I mean, I concur, I don't like the average.
Right.
I mean, a lot depth on it, you know, on the left side of that graphic is that, and the right side would be the combination of the two. You know, that'd be, you know what I'm saying?
Yeah.
Because if you had those lines, or one could be graphically 400 by, and then 400, so you're gonna go 800, but the lot's only 500 feet deep.
Yeah.
So the average won't be the true lot depth. If you're gonna do that, it should say the nearest perpendicular or something like that, you know what I'm saying?
Yeah, I think that's where it, again, just trying to bring clarity to like what would happen in other cases, and I agree with you, you can't have one for everything, but I think if you could have one that's pretty common, and then one that's kind of represents a few differences, I don't think we should have a lot in there, but.
Right. I concur. Then carrying on down, the next one is, we've got, mortgage lot. So, I mean, this is something that's gonna cause a lot of confusion. Says the definition is a lot which is created for the primary or sole purpose of meeting the requirement of a bank or lending institution for a loan or mortgage in cases where property descriptions must be smaller than the total acreage of the tract on which the principal building that is subject to the loan is located.
That's that's probably the best way to describe it. It's really, truly a lot that is created within a lot simply to satisfy a mortgage. So it's only there for legal reasons because it's a,
I'm gonna be devil's advocate here. I got 10 acres and I wanna create a lot for a mortgage. I can go in there and create an acre around it?
you don't, the bank does. The bank requires it. So you don't just get to independently do that. That is only done for a mortgage at the bank's behest.
So there's no differentiation between what the county has until that bank forecloses on that piece of property. Now you created 2 parcels.
So if you had a 5-acre tract and they did 1 acre of the house, then you're left with a 4-acre tract and a 1-acre tract?
It doesn't make sense, and I agree with you, but it exists. And they don't do it all the time anymore. I've got one in Bowden on my desk. I could show you a picture of it. and
No,
you'd be like- You'd say, why did they do that? And I'd say, I don't know, other than.
I'm gonna be devil's advocate again here. So when you got a mortgage company writing a legal description, practicing surveying, just like attorneys get mad at me for writing a legal description or a quitclaim deed, right, and practicing the law. So where's the demarcation of where that comes into effect for our ordinance and where it moves forward? So when I'm saying that, if that 1 acre gets foreclosed on, you automatically, that bank and that issue created 2 parcels of property. So what right does the county have for the remaining portion to not issue anything, if it doesn't meet zoning or anything, to not issue a building permit for anything else for the further use of it?
I mean, you just do, I guess. I had never encountered that, so I can't really answer your question on the spot. It's gonna require a little bit more research than,
I would research that to see if we might even, don't put that thought in somebody's perception to part of the ordinance. If it's something that they create, maybe, I don't know, an asterisk on it or something. I mean, I don't know. If it's not something that meets our ordinance, it's just something the bank does.
well, I mean, when you refinance or get a mortgage, it does still have to go through legal, so it's your question about whether or not that's the, unlawful practice of the law. It does happen with an attorney present generally.
Oh, I agree wholeheartedly. I mean, Georgia doesn't require a survey or a new legal description or anything. They get toted from the early 1900s, and do I think that's right? Absolutely not. I mean, but that's no here nor there. That's way above this table of people, but
So your thought is, how is this implicated in the rest of the code? And if it is not, strike it.
strike it.
Because I think the other thing is, not even a foreclosure if I sell it.
Yeah.
All I've got to sell is a 1 acre and a house to satisfy the bank note. The other 4 acres are there. So now what happens, to Jason's point, what happens to that lot? Can I just say, okay, I'm gonna go build on these 4 acres when you got a 5-acre requirement?
Well, it's a circumvent. I'll be devil's advocate right here. I'm gonna build a house and do a mortgage on 1 acre. I sell it to my son. Well, guess what? As soon as he buys it, I'm coming in and pull a building permit on the other. Does it meet zoning? Might not. You see what I'm saying? That's why, that's my question about it, is how, and I get what you're saying, it's only for purpose of a mortgage and all that, but there's consequences for that purpose of that mortgage themselves. Where does that come into play when it comes time? You see what I'm saying?
Yeah, but
I mean, I get there's 500 pages into a closing that says may not meet zoning requirements, and there's all kind of things it stipulates in there. But with that mortgage lot being created and something happened to it, it's outside of that office, they're kind of just held at hostage to accept it.
I mean, there is just only so much you can ordinance around too, though.
I agree.
So we may have to defer to what is permitted by state law.
All right, can we look into that to see what consequences could become of that? Now, I mean, the package treatment plant in the definition, spelling it's plural down in the definition, package treatments plants, just describe the S in that, but I mean, it does say it's prohibited in Haralson County. I guess you'd have to have the definition of what it is just to say it's prohibited, or be too broad, or whatever. I guess then on down, I guess it's kind of a pet peeve of my own, the state changed its definition of a registered land surveyor back 4.5 years ago. We are professional land surveyors now, so the definition changed it to that.
So you wanted to say professional?
Professional land surveyor.
Okay, and we'll move it up. The rest of the P's.
Correct. Then a right-of-way down there in the definition, we got sanitary storm sewer. Need to add a "and" in between that, sanitary and storm sewer. Separate those two definitions under right-of-way. Page 9.
On the professional land surveyor, is the rest of the definition still sufficient?
Yeah, I mean, because you still, even though you're a professional, you still have to register, just like the professional engineer. You're registered.
Gotcha. Well, I just wanted to
Yeah.
make sure I didn't make any more changes.
No, that definition is basically the same as professional engineer above, except for civil engineering and land. The civil engineering above and land surveyor, that should be the only two differences between the definitions of them prior, except their names. All right.
Back on right away, and I could be wrong. Does it need to say anything about, it says generally the right of one to pass over the property of another? You need to say anything about work, like to maintain or anything in that? The right, maybe not. Generally the right of one to pass over the property of another, or like to maintain or repair.
Well, not every time. Sometimes you'll have just an access. Like when it's these utility ones, yes, it's maintained. But if I've got a right of way across your property to reach my property, then I don't necessarily have the right to do whatever I want to in it, other than cross it.
So would your definition apply to the private right-of-way? Is that what you're talking about, Troy? It's further defined?
Me?
No, what he's asking.
Oh, okay, sorry.
Maybe, I mean, I see that now, I just wasn't that far. I was just looking at that one, the right of way.
Because it covers it in the way of maintenance and ownership of the road.
Yep, sorry, just didn't get that far.
Everybody good up to there?
Up to where?
Right of ways?
Oh, yeah.
The next one's gonna be, and this is where a lot of questions is probably gonna stir and go, but we'll get started on it. Subdivision obviously has a good definition for what it is, but then you roll into subdivision, exemption, next one's major, and then minor. So we can take them individually, but I think there's gonna be some rollover into a couple of others kind of to maybe clean up some stuff on parts. I'm good with the major. No, I don't have any problem with it or anything. Subdivision exemption, you know, it says subdivision of 3 or fewer lots, which does not involve construction of new public or private street. And then the next part of it says because minor subdivisions do not involve the construction. So that next statement brings in the definition for minor subdivisions down below, which I think a lot of it coincides with each other, but I think there's some things that we need. There's gonna be a lot that follows into these definitions as they're described further in the back when it start applying what they are and the restrictions in the back. So there's about probably about 9 or 10 more pages that's gonna go along with that one definition that may need maybe some further homework from the board to really get started in it. But I mean, I can get started if we want to, but I think there's gonna be, I'm gonna stir some questions that may. But
Let's just get started.
I'll spit it out. So on that one right there, like I say, subdivision exemption, when you just read the definition, these are processed administratively by the Director of Zoning and Permits as final plat applications that do not require preliminary plat approval, which preliminary plat approval for that definition has to come through this board and then to the commissioners for approval on it. So that takes that process out for an exemption, which I agree with. The rest of that is the same for, it says, you know, it talks about that any improvements on existing public street abutting land proposed for minor subdivision or installation of utilities along said existing public road may be required to comply with this ordinance shall be done according to plans and permit requirements of this ordinance. But said requirements shall not subject the exempt subdivision to requirements of major subdivision as specified in this ordinance. So it kind of a little bit of contradictory to itself. If you're going to do any improvement, it throws it out of that exemption. So then it pulls in the definition for minor subdivision. I'll read that so you can see what I'm talking about. And it's a subdivision into lots having a minimum lot area of at least 5 acres, which does not involve the construction of new public streets or private streets. Because minor subdivisions do not involve the construction of new public street, they are processed administratively by the Director of the Zoning and Permits as final plat applications that do not require preliminary plat approval. So that same definition is the same for up top for exemptions, minus the requirement of a 5-acre tract. Okay? So then the remaining part of that continues to say the exact same thing as the other about the installation utilities that said public road, right? So once you get along that definition, you go over here get to minor subdivisions, where I'm going with this, over here it says any proposed minor subdivision of this subsection that exceeds 20 lots shall require Board of Commissioners approval and shall follow procedures and standards provided in the county zoning ordinance for conditional uses. Now, there's been some opinions and about the 20 lot cutoff. Where's that cutoff? You know,
Well, I thought what we were gonna do, leave subdivision exemption as it is, subdivision major as it is, but we needed to correct the subdivision minor to say, to a minimum lot area as required by its current zoning, a maximum of 10 lots.
I've got that wrote down. I just wanted to make sure that, are we gonna put that in the definition? Or are you gonna wait and hold it again over here under these other subsections?
Well, I think the first thing we do is correct the definition, and then we build the subsection to meet the definition requirements.
Okay? So, I'm gonna ask the next question. So, if we're gonna put a number on a minor subdivision, we're gonna call it a subdivision.
We're calling it a subdivision because that's what it is, by
So,
definition.
by definition, if you,
We're not calling it a subdivision by the definition of putting a street sign out there or putting, you know, that's major subdivision, that's a development. Which minor could be too, but it's on an existing county road. It's not creating new streets or right-of-ways or roadways.
but it's just more than 3,
It's more than 3, less than 10. But subdivision exemption is what needs to be in place to allow you or I or other property owners to give land to their children or et cetera. Subdivision minor would allow you to buy 20 acres on Jacksonville Road and divide it into whatever its current zoning is, provided you meet all the requirements of said zoning. Road frontage, lot width, you know, but you could do up to 10. And then after beyond 10 would go into subdivision major.
I think the problem is, and it's hard because I don't 100% remember the reason behind everything, but I think that the 5-acre distinction was intentional, and if you take it out, you are going against the purpose of the ordinance itself.
Well, you're not really going against it, you're just allowing it to happen according to its current zoning.
Which is just another way of saying what I said.
But you may be able to
Being-
buy, if Jacksonville Road has got, you know, 20 acres of R1, then this would prohibit you from doing that. But it's already zoned R1, you see what I'm saying?
What's the lot requirement on R1?
2 acres, right? 3 acres.
But that, I think that's the problem, is they wanted to have like, board of, whoever said it, I can't remember, they wanted these things, these divisions to be larger plots.
It
because
was
they-
me,
It was you?
Yeah.
Okay.
and I still do, but I think,
I don't think constitutionally you can do that. If it's zoned something, you can't tell them you can't meet those zoning requirements.
and that's what I mean, I still don't want it to be, but if it's already,
There's not
it's
a whole
already
lot of
zoned that, then they should be able to do what it can be done within that zoning. But this prohibits that because it says lot size of 5 acres.
But
But there's not, it's almost like not a real issue because most of the county that we're discussing anyway is ag, which requires 5 acres. But the verbiage would just catch up with what it needs to be. Am I wrong?
Yeah, I mean, it's kind of like if that piece of property is zoned that, prior to this date of this ordinance being resolved, I should be able to use what was there prior to. This ordinance should not. It should not restrict me on something that the county's already restricted me with by signing me a zoning on it anyway.
And we've already
Back in the-
clarified that by January 23rd of 2024 being in there. So
Right, so that's why I say our current zoning, or if you wanna say current zoning preceding that date, or however you wanna say it. But if there's a piece of property that's already currently zoned out there that can be smaller than 5 acres, and it doesn't have to have any requirements to upgrade it or build anything, I think there's some, I'm not sure legally you can do that as far as what you've already assigned the zoning for it, now you're changing as you go type deal.
Jeff, you here for the inception of that conversation. Do you remember all that?
Well, I think Jason's right on the part, and you are too, right? If we put in effect the ordinance of this date, we've already said, post that event, this applies. Prior to, I don't think you can take this ordinance and apply it to that. No, what I think because if you've already, to Jason's point, if you've already zoned it R3 and people have it approved for those, or just say it's even R1, or let's just say it's 1 acre, you've already got it all set up, you could bust it up.
Well, I mean, municipalities and counties will change their zoning maps all the time and alter what something is zoned. But that's not necessarily.
Yeah, but you have to present that land, that owner, you have to give, we did this in the city of Bremen, you can't just change it, go in here tonight and say, we're gonna change that. You have to publish it, you have to give that owner opportunity to explain why he doesn't want it changed. You can't just blanketly, now you can send out the certified mail. You have to have, I believe, if I'm not mistaken, you have to have 3 months certified mail receipts for it, that you've sent it out, that it was delivered, and you have no response, then you can change that. But if you have a response, and they have an opportunity to come in and have rebuttal against why you want to do that.
So would you go with, if you went with their current zoning, would you go with what the current zoning's road frontage is, or are you gonna go
Yeah.
with the subdivision road frontage?
Whatever meets the current zoning, whatever that is. If it's a 1 acre lot and it's 75 feet wide, and I can do 75-foot wide lots, that's what's there. I mean, you gotta be fair to the people that already got assigned that zoning there anyway. Now, if you wanna change it to that, then that will apply. You wanna change it, you're gonna have to come through rezoning and everything, the whole thing that changes the whole opportunity. I just wanna protect the pieces of property that people own that has a current zoning that's less than 5 acres, that may have 8 acres, and they wanna do 3 2-acre tracts. If it's zoned to allow that smaller acres, I think that's their right, that they should be able to do that.
I mean, that falls under the exemption, which doesn't have an acreage limit
All right,
on
well,
it.
let's say
But you
10
wanna do
acres,
3
and I wanna do
parcels.
5 2-acre tracts, and I'm over the 3, so now you throw me out, now I gotta go meet the 5. That's why I think it needs to say our current zoning by that date.
Yeah, I think
The
my
original
request would be just to go back and research it and tell
Yeah.
us legally what's the steps there, right? If somebody already has a piece of property, 10 acres, they've got it already, it's already R3, R1, make up any of it that's less than 5. Can they subdivide that under the existing zoning? Or, the only other alternative is then everything gets rezoned that's not 5 acres, and I don't know I don't see how that would work, but again, I don't know
Well, the original intent is kind of the way it's worded, was to allow, again, people to divide land for reason of, family members or et cetera, and then allow land that's currently zoned the way it is to be developed according to its zoning requirements, and then have a major subdivision definition where it would invoke a vote, coming before zoning changes.
So, at the end of the day, the issue is the minor, and you just wanna see whether
Well, I
you can
think-
change it to existing zoning.
I think the lot area of 5 acres prohibits stuff that's zoned not agriculture from being developed because of the 5-acre lots. I think it's more fair for it to align with its current zoning requirements, up to 10 lots.
Up to 10 lots.
And even then, let's just say you had 20 acres, right? And somebody wanted to come in there and put 21-acre lots, it's on that way to do it. All we're saying is it should at least come before this board to be aware of, so we can review it.
Well, yeah, we'd have to seek approval then to do 21 lots. Or to do 11 lots, it would
Yeah, anything over
require
10.
board approval.
Right. That's what I'm saying, it's not the matter of,
Yeah, I mean, I really don't
You're just
think
trying to-
unless Nicole knows of a legal way of doing it, you can tell people what to do with their land other than the way it's already zoned.
Other than the way it's already zoned, is that what you
Yeah.
said? Okay.
so I think the overall be the subdivision exemption just needs to be fixed and the minor part taken out. And it just says since a road's not developed or whatever, you don't have to come before, cause it's, what, 3 or less, excuse me.
3 or less.
So if you do that, just remove the minor subdivision wording, cause then it just gets cloudy with what the requirements are in there. This is a subdivision exemption, and if it has any reference, it's just it doesn't apply to those 2 subdivision ordinances or whatever, if it has to be in there.
Yeah,
But
that,
not saying that a minor doesn't have to do it, cause this is technically not a minor, this is a exemption.
exemption. That was what, when I said that, when I first
think-
read that, when I said because minor subdivisions do not involve, I said that you're bringing both of those together into one, and that's where I wanted to stir the discussion about that. An exemption is what it is, exemption that leads to that.
But I'm sorry, I didn't catch the beginning of that. So you don't think we need 3 definitions?
No, I think we need them,
Yeah,
but in the exemption, it refers almost like it's a part of minor, saying
Yeah.
since it's not a,
no, I
just take the
concur.
minor part out of there to
Sorry.
remove the confusion.
I mean, I think in my discussions previously, when we were starting this, I think that if y'all may recall that I even said to do a minor, whether irregardless, if it's anything other exemption, you go through rezoning, because you're developing agriculture property for subdivision development purposes. Taking an agriculture piece of property that you're gonna create 10 residential lots. Right? So what's the difference between it and that, just like the one that the builders just brought through on Pope Road, only because it had a road did it come through here? Right? See what I'm saying? I mean, you wanna be stringent about the whole thing, create a zoning for agricultural 5-acre residential, 5-acre lots, and it go through zoning, if you wanna do that. And then you take out the up to 10 lots altogether. And I think what that stir was that for everybody didn't want to do that because they didn't want to bring in public, to bring that into the public for that decision for everybody out there. You may be swayed to whether you're going to allow them to do it or not.
No, I mean, that wasn't my position
No, I'm not
on
saying
it.
you.
Yeah, my position on it is why create extra paperwork if we're okay with developing 5-acre lots, which I believe is good growth? Up to 10 lots, if they want to go out and do 11 lots or 50 lots, then I think it's fair to come before the board, because we need to look into some other things, water supply, school system, we need to, but I think 10 lots, in theory, you're adding, 20 children, so we could probably tolerate that loosely.
I concur if you have one, but if you've got 10 lots on this road and 8 other roads, you just created 80 lots.
Yeah, but I don't.
I mean, I'm just throwing that out there.
Yeah, I mean, I just don't.
We know
see-
what's
see
happening.
that
What is the number you're thinking, 5 lots? Are you just thinking just make it cut and dried, if it's a minor subdivision, it goes through?
I think
approval?
what I would see is if it's a minor subdivision that you're gonna allow, leave it at 20 if you wanna leave it at 20, but if it's a minor, anything above 3, it should come to this board and then the Board of Commissioners. If it fits that 20 lots, we should be able to say what it is or what it's not, no, we're not, and send it back. Because if you read, it's what I'm saying, all this is gonna tie together if you give me just a minute.
Well, if that's gonna be the case, then subdivision minor needs a simple definition of any division greater than 3 lots.
Correct. Because then you go to delegation of powers to the Director of Zoning and Permits. And you start reading, the Director of Zoning and Permits is vested with the authority to review, approve, conditionally approve, or disapprove final plats of minor subdivisions and minor re-subdivisions, lot combination plats, lot line adjustments, dedication plats, construction plans, and final plats of major subdivisions when preliminary plat approval has been obtained from the Board of Commissioners. All that's good, like that. The next question is where I got. The Director of Zoning and Permits shall also be authorized to review major subdivisions and major re-subdivisions for conformity to the requirements of the ordinance and make reports and recommendations to the Planning Commission on major subdivisions and major re-subdivisions, and to administer, interpret, enforce revisions of this ordinance. That's where I think in that, if you create that number, it should be added to that they look at it, review that, and it comes to us. Then if it's, everything's good on that certain number, it turns around and goes back to their office for approval. It don't go any further. See what I'm saying?
Are you on page 14?
We don't
I'm
know,
at
somebody
39,143.
took our numbers away. I think it is 14 though.
It'd be on
of the
page
redacted.
13 at the bottom. Delegation of powers to the Director of Zoning Permits.
But I think the numbers changed when they did some redaction. It created less pages.
Nah, these ain't got no pages. It's the same number. The blue represents what's in here, 39-1.1-4.3. That's why I'm saying that these 6, 8, 10 pages right here is going,
Take a while.
it's gonna take a while. And I'm just putting thoughts in the boards to have thought process when they're looking at it, reading where I'm coming from, where I'm not. You know what I'm saying? Because that's, if you're gonna let that office do that much of it, you should be able to add it to that number of lots that is in there for it. I don't wanna make it any more cumbersome than it is already, but
Sure you do. So what was your issue with this, the delegation of powers?
I'm just saying, if you change that number in there, that certain number of lots in there should be
It
in
needs to be in here
that too. Whatever that is, cut off or whatever,
Yeah,
needs to be added in that portion of
I
it.
concur.
That's why I say these 8 or 10 pages all gonna tie.
Yeah, I mean, I would agree. But to be fair, that 10 lots was requested to us
Correct.
by the the permit office, the administrators. They just feel like 20 lots is too much to be able to handle without review. Am I wrong?
No, that's correct.
So,
I'm good with it.
so going back to subdivision minor, for now, and I know Nicole's gonna look into it, we're wanting to make the change that it says having a minimum lot size, however you would word it, to meet current zoning requirements and up to 10 lots.
Yeah, subdivision to lots having a minimal lot area of at least, or however you want to word it.
And you're wanting to strike the last few sentences. Is that what you said, Jeff?
On the subdivision exemption.
On the subdivision exemption, strike those?
Well, I was just talking about striking that second one where it says because minor subdivision is not involved in the construction of. Why is it just, exemptions are processed administratively by the director of zoning permits? And just take all that out around the minor subdivisions. Just explaining how those are approved.
Yeah, you could take that street, you could take because minor subdivisions, you could take that part out to where it gets to the comma, they are processed, you could just private, construction of new public streets, which does not involve that, public streets, comma, they are processed administratively by the zoning department. This final plat application is required, and do not require preliminary approval. Then you could just strike the rest of that. Because then if you do any improvements to the existing road or anything, that just totally takes you out of that altogether.
So you want to strike that sentence up to that comma on subdivision exemption and leave subdivision minor alone other than what we've already stated changes to. Current zoning requirements up to 10 lots.
Correct.
And then just to bounce forward, if that's 16 where delegation of powers, you want to add verbiage about 10 lots to the second half. That'd be the first half of minor subdivisions.
Yeah, wherever it is
So
in
they'll
there
have the
where that number needs to be dedicated in there.
To approve, conditionally approve, or disapprove final plats of minor subdivisions up to 10 lots.
I don't, subdivision plan.
So on the minor subdivision, you're just saying subdivision lots have minimum lot acreage of at least 5 acres, or no more than 10 lots or something like that, is that?
No,
Talking about changing in the minor subdivision first, I'm just,
yeah, in the minor, you gotta say, or current zoning.
okay.
You gotta somewhere have to get that wording for current zoning involved.
Okay. Or is it, zoning prior to whatever the effective date of this is?
Yeah, you could do that. Yeah, you could put current, yeah, however you wanna
Current zone
designate
will,
it.
current zone will work regardless, even if you got it rezoned, it would fit. But it's gotta go through this board to get rezoned.
Yeah, because then that would give you the rezoning would take you, that's not something that's anything to do with minor either way, 20 lots or less or anything.
Right. And talk about hardwood trees, shade. Good there. Are y'all caught up, or are we bouncing around too much?
I think we're caught up.
You good with the delegation and all that, so we're good on that, what we're in that.
Provided we add the 10 lots in that, yep, we're good with that.
All right, your next one down there is 39-1-5.3, subdivision of land. Y'all read that and see if.
I know what you're gonna say already. I'm gonna let you and Nicole argue that one out.
Some way we gotta,
You have a problem with the no person shall.
I have the problem with anybody from state legislator all the way down to this board telling me I can't sell somebody a piece of property. And that's what that statement says.
Any parcel of land not subdivided under the requirements of this ordinance. I mean, is that not just saying that you can't sell it unless it's under the requirements of this ordinance? No, so you can't promise to me that I can buy your 10 acres and divide it into 1 acre lots.
That is correct. Read the next, read that one down there, the other one. The description of such land by metes and bounds in the instrument of transfer shall not exempt the transaction. So that statement says I can. Some way we gotta come up with that subdivision of land deal. Somehow in there's gotta, protect the public and the county. I mean, I get what it is, what you're saying is I can't have a 10-acre tract and say you an acre and you come in and pull a permit that don't fit. I get that, that's what that is, but if you need that acre to go to something or something else, it may not fit this ordinance. So where do you gotta do? You gotta go through a variance application or what? I mean, there's,
So you just add a provision for without approval,
Again, and maybe I'm not reading it clearly, but what I think the intent is that I can't come to you and say, hey, I got 20 acres of land for sale, and here's the stuff that shows 1 acre lots, and I've already had it all done, and here you go. You buy it under the pretense that I can go ahead and do it, and it's never been rezoned.
correct.
It was ag the whole time.
I think that's what I'm reading it as, not, I'm reading it as talking to the seller, not as the buyer, which I think you are too, but it's just saying if you're gonna sell this land, it's gotta meet the requirements of this ordinance. You can't sell it under the pretenses it's already been subdivided. I think it really protects the buyer.
Right.
No, I was seeing
Oh,
what you
you're
thought.
waiting. Yes, that is what I am reading it to say as well. And that, including the metes and bounds of the entire tract doesn't exempt the transaction. So I have this big thing and I'm selling you all 20 acres and I'm giving you the legal description of the 20 acres, but I'm including this proposed plat that hasn't been approved by planning and zoning. Like that inclusion of the proposed plat, we're basically saying that doesn't give you any vested right to have this plat that was given to you. You can buy the 20 acres that are described by the meet and bounds, but your proposed plat that was included is invalid.
Okay, then the next part of that, and it's, I don't want to drag somebody that's not here to represent themselves. Our clerk of court needs to know that if that other little provision gets sent over there, they've gotten better, but they'll still record that plat. So once it's recorded, what happens then?
Gosh,
I think it would be recorded prior to the date of this ordinance. So if it's recorded after that, I guess the question is, what's legally bound then? It was recorded, but it doesn't comply with the ordinance.
Correct.
So now what's the next step, or is there one?
I mean, we just had two of those that came through that were here. Remember the one that was up off of, not Francis White Road, but there was another road up there that was platted previously with an easement and 10 tracks. It was platted, recorded, don't meet zoning. But it went through. I think they're building 1 acre tracts out there. So that's what I'm saying, that there's some definition in that, but there's also another office that's got to, they got to understand that. Plat Act, there's 3 statements for Plat Act. And minus going to that every plat has to come to your office and be stamped to be recorded. prior to that,
They're supposed to be.
but they're not, they do for the cities. They know the cities, if it's in the city, they won't record it unless the city signature's on it. But they don't for the county because their one statement says this is a retracement survey. The onus is on the surveyor to put the appropriate note on there for the clerk of court to follow. There's,
Why would you do that? Cause I mean, there's surveyors that come in that are not in the county and never done any work out here. They don't maybe know that to do it, correct? Or is that a requirement regardless of what the ordinances are in the counties, or
No
is that just
statements?
this county? Yeah.
no statements on that plat, or that is Plat Act. So if he's a surveyor,
So
professional
regardless,
registered from the state of Georgia, he has to have one of those three notes on there.
yeah.
And if he chooses to put one on there, it's a retracement, and it's not, it's a 5-acre cutout, they don't know that. There's a bunch of them that's had to come, you can look on the website and follow it and see and look, they'll be recorded, and then that person comes in, yeah, it did meet the 5 acres, it met it. But then you'll see a revision on it that then has their office signature on it that's re-recorded again.
Yeah.
So that's what I'm saying, part of this statement with the clerk of court there's some involvement has to do with that, however that gets resolved, or when it is. I just don't want,
But I think this statement gives this board and the Board of Commissioners, this county, the legal teeth to fight back against something that, not necessarily malicious at the courthouse, but somebody sold land with the intent of, and they already know that they got their plat passed through and got it approved, but still, we go by this ordinance when they come for rezoning to say, no plat or land subdivision shall be unless it meets this ordinance. Well, when was it recorded? Okay, well, it didn't come before this board to get cut out into 20 lots.
okay, I'm good with it, I'll just read it and,
I mean, that's kind of, I think we leave it. I don't think it's doing any harm. I think it's protecting Cass County.
The issue is that if it's happening, it does say, you know, shall not be entitled, and it shall be unlawful, so we gotta figure out.
That's an internal communication.
But
problem, not-
also,
Yeah,
what recourse do you have? If you have somebody that's doing something that you've declared unlawful in your ordinance, are we pressing charges? Are we citing? Are we not allowing that surveyor to survey in Haralson County? Like, what are we doing? I just need to know
I mean,
what that means.
I'm fine with that. I don't know how we impose those legal recourses. though.
Yeah, so that's the question I think that I'm hearing is, well, what does that mean? Like, are you guys obligated to do it once it's been stamped? And then if you're not, how do you tell somebody that you're not? And then if somebody's doing it when they're not supposed to do it, how do you let them know? And do you follow up with the teeth that you talked about?
Yes,
Those are a lot of interesting questions
yes, the answer is yes to all
that we should look at.
Well, I think it's just being sure too that whatever the order is in a county aligns with what the ordinance is. To Jason's point, if the city signs off on them, and that's the way it's supposed to go, is the commissioner, you know, where the clerk here is supposed to sign off on it before it goes to the clerk of Superior Court. And if it's not signed, somebody brings it in there, they just reject it and say, hey, you gotta take it up here, and
But I think if that
That's
raises,
what the procedure is supposed to be now, but there are some that we keep finding that have slipped right on through, and they went on and stamped it and never checked for our signature, so.
I think that's something that's gonna have to be in that office as part of their checklist, right? I mean, that is the due diligence for the clerk of courts. They have certain things that they have that they say that plat meets Plat Act, right? They can't blindly do it. And I mean, the bare minimum, on that plat, you list the tax parcel of that and then, or it's a portion of, if it's ever a portion of, I mean, the bare minimum that office should pull up Q Public and look to see if it's within a half an acre of what it is of an existing parcel. If it's a 5-acre tract on a survey and it's out of a 80-acre tract, they should have enough awareness to ask the question and say, you need to go see them. But if it's within a certain amount, I mean, obviously, if it's never been surveyed, you could be, I mean, you're gonna be off a little bit, but relatively to what it is, 5 acres cut out of something, yeah, it meets everything, it just didn't come to this office first, so what's the recourse, right?
Right.
So I think it's some communication that may be that we're having issues over here that needs to be communicated with their department so that some other things gets resolved in that manner, which would then resolve itself. I'm gonna stop right there.
Okay. I was going to say, I actually have to go. I got to go to the
No, I'm gonna
Christmas
stop
party.
right there. I just going to task this board with the next.
You already given homework your
Yeah.
first day?
You asked for it, buddy.
So at our next one, what pages will we try to go through?
I wanna go through,
What?
I wanna go through, item. Let's don't get into that. Let's cut it off. Let's go through item 39 dash. Let's go through up to final plat, 39-1-15. Whatever number page that is. Be right, I think it's 26.
Okay.
So up to 115, don't go 115.
Yeah, don't do 15 because then you start to getting into all these tight tables for requirements the next 30 pages.
So you're gonna go from where we're at now to that section?
Yeah, I mean, I would say what we covered tonight on these definitions, maybe look at that, read that, think about it a little bit. If something comes up that you feel like was different than what needed to be here tonight, bring that in, but let's go up to that page, up to final plats. You gonna start it and me finish it tonight?
That's what it says.
All right.
So our next meeting will be January 13th.
10th. Nope, that's February, sorry. 13th.
13th.
All right, any more business we need to cover tonight? Do I have a motion to adjourn?
I make a motion.
Second.
All in favor?
Who got this?
I don't know, somebody's had that was left, it's not,
We hadn't probably got it yet.
must be getting ready.
This one was proposed.
Approved merchandise.